Back on the record. Court will call CR 10-22-5874, State of Idaho versus Devin James Willcoxon. State is present, represented by Jeffrey Thomason. Mr. Willcoxon is present along with his attorney Curtis Smith. This is the time this court set aside for Mr. Willcoxon's sentencing. Mr. Smith, is it planned to proceed with sentencing today?
It is, Your Honor, yes.
All right. Mr. Willcoxon, before I turn it over to your attorney for comment recommendation, I just want to go through the procedural history of your case. You were originally arraigned in front of me August 29 of 2022, and at that time you had been advised that you'd been charged with a count of rape wherein the victim was 16 or 17 years of age and you as an individual were more than 3 years older than the victim. You pled not guilty. However, back in April of 2023, pursuant to a plea agreement, you agreed to plead guilty as charged. That plea agreement also contained some particulars that were in fact reached through a process of mediation. Is that correct, Mr. Smith?
That is correct, Your Honor.
All right, and through that mediation process, was the victim involved, do you know?
Yes, the victim was involved.
All right, I appreciate knowing that. The plea agreement that you reached with the state indicated that the state would recommend I place you on probation as part of your sentence, with the additional recommendation that you comply with all things recommended under the psychosexual evaluation and that a no contact order be extended for 20 years. You reserved your right to argue what an underlying sentence would be. You and your attorney will also recommend I place you on probation. You also agreed that you would comply with all items that were outlined in the pre-sentence investigation. This agreement was not binding on the court, and following that agreement, I ordered that a pre-sentence report be prepared, as well as a psychosexual evaluation be prepared as part of that report. That has been completed, and that investigation report was filed August 7, 2023. Mr. Willcoxon, did you have an opportunity to review that pre-sentence investigation report?
Yes.
Mr. Smith, is there anything in that report that needs to be corrected or clarified?
Thank you, Your Honor. There is not. We will make appropriate argument at the time, but no changes to be made.
Any objection to me relying on that report in the PSC for purposes of sentencing?
No.
Mr. Willcoxon, is it your intention to stand by your guilty plea previously entered?
Yes.
All right. Mr. Smith, are you going to have witnesses today?
Judge, based on the fact that this was mediated, we have decided not to call witnesses today.
Appreciate that. Mr. Thomason, are there witnesses or victim impact statements today?
Not that I'm aware of, Your Honor.
All right. With that, Mr. Smith, I'll turn it to you for comment and recommendation.
Thank you, Your Honor. Well, Your Honor, appreciate the court and counsel's time. This has been a case where both sides have worked very hard to reach a resolution. Again, this resolution came after a mediation with a senior judge, with the victim participating. We're hopeful that that carries some weight with this court as far as accepting the plea agreement. My client's previous history and previous record is next to nothing. He did have a misdemeanor some years ago in 2016, as you can see by the pre-sentence investigation report. That is the only thing in his record. That involved alcohol, as the court's aware, and one of the recommendations is that obviously my client may seek some treatment and some help while he's on probation for that issue. That is fine, and he recognizes that he may be asked to do that, but I think he also feels very comfortable that he's been doing the right things in his life during the pendency of this case, and he's in really good shape that way. As the court knows, he's been on some pretrial release and some orders from this court, which he has followed to the T. There's been no problems with that. There's been no recommendations from pretrial services for the court to have to review that release in any way, shape, or form. I would also indicate to the court that my client did not contest hearings that put the victim through any further, trouble or consternation under the scenario of the court system that's adversarial and that could be done. He didn't do that. We were able to reach this again after a lot of hard work by both parties and a mediation. And we think it's a good agreement, Judge. We think there's a lot of things in it that make sense for why this court should feel some confidence to follow that. Let me just talk about a few of those. First of all, the court's well aware in the pre-sentence investigation report that my client comes in at a risk factor of an 8 on the LSI, which is very low. Not surprising in light of the fact that he hasn't had much of a criminal record and all of the things that he's got by way of pro-social things going on in his life. He's well employed. Even when he lost his job over this event, he was able to get re-employed and he stayed employed. He's a hard worker. He's a good young man. He has stable housing. He has a good support system. They're here in the room with him today. Part of those people, his father's here. He's got good support with people who love him and care about him. And he has some internal motivation to make sure that he follows what this court orders for him today. We also have completed a psychosexual evaluation by Dr. Robert Lasota, and that indicates that my client is low risk for reoffense. I won't go into all the details. I know this court's had an opportunity to review that report, but my client scores very well and is in a spot where all the prognosis is that if he will do what's asked of him and get the treatment and help that he needs, that he will be in a good spot to move forward in a positive direction like he's already been doing for the last year and a half since this event. So, Judge, I think in light of the fact that my client has shown the court that he can be in the community already and be safe, that he's got these low factors, the pre-sentence investigation report, they also recommend probation. So I think that they're recommending the same thing that came out of the mediation. And so we appreciate all of these folks who have been involved in getting materials to this court so that the right decision can be made. There are days where I know that my client would love to go back and take back what happened. This was a scenario where he was a manager and this person was an employee and they got friendly and things happened that shouldn't have happened. And he's thought about this a lot since then. He wishes that it hadn't happened. He wishes he could go back and change that. He can't, but he and I have talked about how he's spending every day moving forward trying to right the wrong, trying to show people that he is a better person than that one moment. I don't think that is vastly different than all of us in our lives when we make mistakes. Some of us obviously don't find ourselves in the court system, but we still all make mistakes and we have opportunities hopefully to overcome those mistakes and become better people and better community members. And I think my client is determined to be that kind of person and to show you and the state and the victim and others in the community that he is that kind of person and that he can move forward in a positive direction and be a contributor rather than a drain on society. So we would invite the court to accept the plea agreement. I haven't made a recommendation about an underlying sentence. I think I would prefer to let the state give their recommendations if that's all right. There's been some discussions about where that might end up, but I think after Mr. Thomason has his opportunity, if we feel like we need to come back and make any argument on that, I'd be happy to do that if the court would allow us to. But otherwise, I think I would just recommend that you suspend the sentence, place my client on probation with the terms and conditions that came out of the mediation. My client did serve 2 days in jail. I recognize that some may feel that is not enough for something like this. I think that when you take into account the many things that my client is going to be doing over a lengthy period of time with probation, be on the registry, and other things that he's done for the last year and a half of being on pretrial release and basically been living a term of probation already, we are hopeful that the court might just suspend the sentence, give him no more local jail time. If you do give him local jail time, we're hopeful that it can be done on work release so that he could keep his employment. This court's well aware, and I understand that people bring this upon themselves, but when you lose a job after a charge like this and you have the fortitude to go out and find work and be a contributor, pay your taxes, continue to support your family. He's got a daughter and some obligations. He's been able to do that, and it hasn't come from somebody who just decided that they'd stay home and sit around and watch TV when they lost their job. And we're hopeful that there might be a structure that allows him to keep that employment, which is a primary component of his success. And so with that, we're happy to answer any questions that we may not have addressed today, but we would submit it, and we appreciate the court's time. Thank you.
Thank you, Mr. Smith. Mr. Thomason.
Thank you, Your Honor. Your Honor, as the court is aware of this Mr. Davis case, I'm filling in for him, but I familiarized myself with the file here on the case and had some conversations with Mr. Davis as well as far as recommendations. As far as the plea agreement goes, state is recommending probation, and as a term of that probation that he comply with the recommendations as contained within the psychosexual examination or evaluation, excuse me, and strictly adhere to the no contact order. We're also recommending that the court extend the no contact order for 20 years. And in regards to the probation recommendation, we are asking that the defendant take a polygraph as part of his probation intake. And is in regards to underlying sentence, state is asking for a fixed term of 5 years and an indeterminate time of 10 years with 90 days of local jail time minus whatever credit. I believe Mr. Smith said it was 2 days served. Now, as the state's reviewed the PSI also recommends probation, that they complete a sex offender treatment program. In regards to mitigating factors, Mr. Smith really laid these out well. Very low LSI, a very low risk to reoffend, according to the PSI. Very minimal criminal history. There was a DUI, as Mr. Smith mentioned, that he received, was dismissed pursuant to a withheld judgment. And the PSI also mentioned he was unlikely to engage in rape behaviors. So as far as aggravating factors were, Mr. Willcoxon, he knew what he was doing was wrong. The victim was very 15, 16 years old at the time. They worked together, and I believe he was in his early 20s. Essentially, knew what he was doing was wrong, manipulated her, the situation, said things to her about that, she was the only thing he had left in his life, and for 3 years she didn't report this because she just recently got the courage to come forward to report this to law enforcement. But over this period of time, the defendant had even mentioned to the victim, "Don't tell anybody, because if you do, I'll get in trouble." And so there was this manipulation essentially that was going on throughout the course of this relationship. So, Your Honor, the state would be asking for those recommendations. The probation, 5 years fixed with 10 years indeterminate, 90 days of local jail time. And so with that, the state will submit.
Thank you, Mr. Thomason. Mr. Smith.
Judge, thank you, and I appreciate the comments that have been made, and my comments don't necessarily reflect that I feel like I have to do this because what was said, because I think what was said was very appropriate, and we appreciate the state's comments. I would indicate that there might be something here that I want to make sure that the court doesn't misunderstand. There was something in the report that kind of indicated that my client certainly felt bad about what had happened, but maybe wasn't owning the full responsibility. That got triggered when Mr. Thomason indicated that some time had passed before the reporting the victim. And Judge, I don't point this out because I think that this is in some way should be thrown towards the victim in some negative way. But there were some things by way of that manipulation that were happening there between the victim as well. For a short time, my client had been asked to give money to the victim and the family. And they had indicated that if he would pay them some money that this would go away, that it wouldn't happen. My client didn't do that. He took that higher road. I don't place any judgment on the fact that the victim did that. These are hard things. Emotionally, they're hard. Things happen to people that sometimes make them react in a way that they normally wouldn't. We understand that. And I would feel bad if anybody thought that I in some way was throwing stones in that direction because of that. But I think that that's an answer as to why in the report it indicates that when he was answering the questions about the victim and how this unfolded and the time that had passed, that's one of the things that had happened in that time frame. And so we would be remiss if the court wasn't aware of that, which is part of what had this case unfold over a period of time and not immediately by way of a reporting. But once it was reported, it became clear that my client had not engaged in that. He had not engaged in trying to cover up some crime by paying somebody money, even though that was requested. And I think that it's important for the court to recognize that within the context of a few things that were said within the report, and then of course the reminder by the state that it had unfolded with a delayed reporting. If you've got any questions about that, I'm happy to answer them, but I felt like in general terms the court needed to know that. As far as the actual sentence, I don't have a lot to say about that. I think that I had come in with an understanding that maybe the court would consider a 4-year fixed with some indeterminate time. And you've already heard us with regards to the local jail, so I would submit it knowing that that was probably where our argument was on that type of sentence.
Thank you, Mr. Smith.
Thank you.
And just so everyone is aware, I am aware of the claims that there was a request for payment. I haven't taken that into consideration at all. From my standpoint, Mr. Willcoxon, and I'll turn it over to you in a moment, the things that I'm focusing on are the events that actually led to the charge, which would have occurred before those events. So I'm not taking that into consideration one way or the other, just so you are aware. Now, having said that, Mr. Willcoxon, before I sentence you, you have a right to address me directly and make your own statement. You are not required to make any statement at all. And I want you to know that I place no negative meaning or negative inference on any defendant that chooses not to make a statement. But if you want to, now is your opportunity.
I would like to say that I'm very sorry for the things that happened.
All right? Anything else?
That's it, Your Honor.
All right, I appreciate that. Mr. Willcoxon, are you fully satisfied with the representations you received from Mr. Smith in his office in these matters?
Yes.
Mr. Smith, any legal reason I should not impose sentence today?
No, Your Honor.
All right, then with that, Mr. Willcoxon, based on your previous plea of guilty, it is the judgment of this court that you are guilty of rape under Idaho Code 18-6101, subparagraph 2, wherein the victim was between the ages of 16 and 17 years of age, and you were 3 or more years older than the victim. In preparation of today, I did go back and look at the entirety of your file, and that includes the pre-sentence investigative report as well as the psychosexual evaluation. And in preparation of today, I must keep in mind the objectives of sentencing that have been outlined by the Idaho Supreme Court, and those objectives include punishment, rehabilitation, protection of society, and deterrence for both you and others. I also have to look at the factors that are outlined in Idaho Code section 19-2521. And those are factors that essentially give the court guidance as to why it would or would not place someone on probation. As I review your file, I will note some things that went into my decisions, some of which were pointed to by your counsel or by the state's counsel. First of note is that you don't have much in the way of a criminal history. You had the one DUI, and you were actually given a withheld judgment after successfully completing probation. So this is your first conviction. The pre-sentence investigation, consistent with recommendations from your counsel and from the state, recommend that I place you on probation. I'd also recommend that you participate in sex offender treatment program, and that you might benefit from a substance abuse treatment, counseling or programming, just based on some of the factors that showed up on some of your testing. I note for the record you are now 29 years of age, but the incident happened in 2018, so there was a delay in reporting. Not unusual, Mr. Willcoxon. I don't take anything from that other than to recognize that between the time of the events in 2018 and today, you have no other criminal history, which suggests some things to the court. You have an LSI of 8, and let me explain that to you. The LSI is an actuarial assessment that the courts rely on that help the court, and they help any probation or Department of Corrections individual determine the likelihood that you could commit another crime. The lower that number, the less likely it is statistically that you would commit additional crimes. So it weighs in your favor that your LSI is so low, being an 8. And that LSI is driven up by the crime that you committed, but it's driven down by the fact that you have support, you have employment, you've maintained employment, you have education, and those sorts of things. Aggravating factors that this court looked at included the question with respect to responsibility that your attorney addressed. But the biggest aggravating factor is that the event happened at all. You were in a place of trust and power, being older than this other co-employee. Maybe you took advantage of that. You certainly ended up in a relationship with this individual that shouldn't have occurred because of your age in relationship to the other individual's age. And I think that there was probably, I don't know, an 8 or a 9-year age difference. And when you're the adult, Mr. Willcoxon, you have to take that responsibility. There were significant mitigating factors that this court did look at. For purposes of the pre-sentence investigation, and when you met with that investigator, you did take full responsibility for your own actions. And I take that into consideration. You do have support in the community, and some of that support is reflected with you today. You do have a high school education, you are employed, you have maintained employment. And there were other factors in the PSC that this court took into consideration, and I just want to touch on those briefly. The ultimate conclusion of Dr. Lesoto on your psychosexual evaluation is that you are low risk to reoffend. That weighs in your favor. And ultimately, you are amenable to treatment in the community. Now, he did have some concerns with respect to motivation. I think that was related to your comment of you just as soon put this matter behind you. I'm sure you would. But if we don't address the underlying issues that triggered your activities, then you potentially are a greater risk to society. Dr. Lesoto, through his testing, indicated that you are on the low end of recidivism. He attributes the crime to sexual thinking errors. He also attributed it to seems to be some lack of self-confidence in interacting socially with females, adult females that are the same age as you. And the suggestion was that may be why you ended up in a relationship with somebody that was younger, and in this case was a 16 or a 17-year-old. He indicated that your actions were not a product of paraphilic disorder, which again is helpful to this court. Your thinking errors are more likely in lines of somebody who would find and groom, the terminology is groom a victim, but you don't have predilection toward underage individuals. It is a interesting position where this court is looking at an individual and there is a punishment aspect that it has to be aware of, and yet a significant, lengthy, immediate punishment actually makes you more dangerous to society statistically. Individuals that have no criminal history, that are placed in the correctional system, actually come out of that correctional system more likely to commit more crimes in the future than if we address your problems through a probationary period and through treatment. And all of that weighs on this court for purposes of how best to protect society in the long run, how best to create a deterrence, and how best to rehabilitate you. All that being said, Mr. Willcoxon, it will be the judgment of this court that you be sentenced to the custody of the Department of Corrections as follows: for a fixed minimum determinate period of time of 4 years, followed by an indeterminate period of time of 11 years for a unified sentence of 15 years. I will suspend the execution of that sentence and I will place you on probation for a period of 10 years, subject to the following terms of probation. I will order that you comply with the standard terms of probation. I will also order that you comply with the sex offender terms of probation. I will order that you serve local incarceration of 45 days, giving you credit for 2 days. I will authorize work release for that. As indicated by your attorney, it is difficult enough to find employment and keep employment when you have a conviction. So I will authorize the work release, but there has to be some punishment aspect for your activities. I will order that you complete 100 hours of community service. There is a $60 fee for workers' compensation for that service. I will order a fine in the amount of $1,500 plus court costs. I will order a civil penalty under Idaho Code 1953-07 in the amount of $2,500. I saw a motion for restitution in the amount of $600, and that was for the testing.
Your Honor, we looked at that and understand that that's a reasonable request and that's what the testing cost, and so I think we were stipulating to that figure.
And having said that, Mr. Thomason, do you have any other motions for costs and fees that I am unaware of, or do you want to leave that open for 30 days for review?
I'm not aware of any, but just to be safe, we could leave that open to the
All right,
process.
so I'll order the $600 today, Mr. Willcoxon, but I'll leave the restitution open for 30 days. What that means is the state will review its file. If it feels that there are additional matters that you need to pay for, it will file a motion. You and your attorney will have an opportunity to review that motion, and you are entitled to have a hearing on any restitution motion. And if there are some questions or some objections, you and your attorney will file that motion, we'll have a hearing. If I get a motion for additional restitution and I don't see any objection within a couple of weeks, I typically then would just enter an order for that. Do you understand that?
Yes.
All right. You will be required to register as a sex offender pursuant to Idaho Code. Your probation officer will give you more information on that, but you, just so you are aware, so that there is no question, you need to register within a handful of days. I think it's 2 days from today. Mr. Smith can give you some additional instruction. You also need to be advised that if you change your address, you need to make that change of address within typically 2 days. It's frustrating for me when I end up with cases of somebody who fails to register, and so you are aware, if you fail to register or you fail to keep an updated address on file, that is an additional felony charge. It's frustrating to this court when I see those because it's something very simple that people fail to do. We'll order that you attend sex offender treatment. I will note that Dr. Lesotho indicated that he had a concern of you going through that treatment in a group setting because of the possibility that a group setting could actually be detrimental to you. And he is recommending that you have sex offender treatment more on an individualized setting. I will leave that up to the treatment provider. That is best served for that provider to determine the appropriate settings for that, but I will order that you complete that. We'll order that you do maintain full-time employment. I think that that is beneficial as you go through this. We'll order that you do not use, possess, or consume alcoholic beverages. We'll order that you undergo at least a substance abuse evaluation, and if that evaluation reflects additional treatment, that you follow through with any treatment that is ordered. And we'll order that you do not sell, possess, or consume controlled substances unless they are prescribed to you, and then you only use those in the manner in which they are prescribed. We'll order that you submit yourself to random testing of your bodily fluids for controlled substances, and you submit to warrantless searches of your person and property. You will be required to provide a DNA sample. Anybody who is convicted of a felony in the state of Idaho must provide a DNA sample. And we'll also order that the no contact order be extended for 20 years from today's date. Just so you are aware, Mr. Willcoxon, the victim listed in a no contact order will have the opportunity to extend that even longer. They would have to do that by application. Mr. Willcoxon, do you understand the sentence I have imposed today?
Yes.
Do you understand the terms of probation that I have outlined today?
Yes.
Mr. Smith, anything that I did not address or I need to clarify?
Your Honor, I don't believe so. I did have a question, and you might have been still going to get to this, but would the court allow him to check in on Monday night? That'll give us time to set the work release up.
And I will allow that because I'm authorizing work release, and I know that there's times you need to set up the work release and your work schedule. So I will order that you report to Bonneville County Jail no later than 5 p.m. August 14, 2023. You can report sooner, but you need to report no later than that date to serve those days.
Thank you, Your Honor. No other questions from us.
Mr. Thomason, anything I need to clarify or I failed to address?
Nothing from the state, Your Honor.
Mr. Willcoxon, do you accept probation on those terms?
Yes.
Did you do discretionary jail?
I did not do discretionary jail. I am going to have 180 days of discretionary jail. Now, Mr. Willcoxon, what that means is if you have probation violations, you could be ordered to serve one or all of those days. If you have no probation violations, you won't have to serve any of it. Do you understand that?
Yes.
You understand that's an additional term of your probation?
Yes.
Do you still accept probation on those terms?
Yes.
Do you need time to make payment on these fines and fees? You're looking at north of $4,000.
Yes.
Starting in about 30 days, how much do you think you can pay each month?
You can pay $100 a month, Your Honor.
All right, I will order $100 a month starting, we'll go September 15, that's a Friday. So each month pay that $100. Do you understand that?
Yes.
All right. Mr. Willcoxon, do you have any questions about anything that we have done here today?
I didn't. don't think so, no.
Yeah, any questions of what's expected of you?
No.
All right, and with that, Mr. Willcoxon, you need to be advised that you have appellate rights that now attach to your case. You can appeal my decision. You have 42 days from today's date to file that appeal. You can also seek relief under Idaho Criminal Rule 35 if you think my sentence is illegal or too harsh. You have 120 days to seek relief under that act. Finally, you can seek relief under the Idaho Uniform Post-Conviction Relief Act. You have 1 year after your appellate rights expire to seek relief under that act. Do you understand your appellate rights?
Yes.
You have a right to have an attorney assist with those appeals, and if you cannot afford one, one would be appointed. Do you understand that?
Yes.
Mr. Smith, anything else that I need to address today?
No, Your Honor, thank you.
Mr. Thomason?
Nothing to say, Your Honor.
All right, and we're on recess on this matter. Mr. Willcoxon, you'll have to stick around and complete this form for the payment agreement. With that, we are in recess. Mr. Willcoxon, good luck to you. Mr. Smith, you are excused.
Thank you, Your Honor.
Oh, yeah.